All right. So to get us started, Scott, why don't you just give us a little bit about your background and why you're choosing to make this run at the county attorney's office, and what you think you will bring to the table or bring to the office.
Well, I'm kind of a small town born and raised guy. I was born out in Western Iowa. I served 6 years in the U.S. Navy thereafter. And then I did another 6 years in the Army National Guard. I'm a member of the American Legion and the Veterans of Foreign Wars. I went to college at Buena Vista over in Storm Lake. And then I went to law school at University of Iowa. And then I've been up here in Dubuque ever since. So I've been here about 32 years. I did 15 years with Hammer and Simon Law Firm, and then started my own office. And then I've been doing that for about 17 years. So why am I running? I ran 4 years ago because I think 4 years ago the office needed, excuse me? Oh, I thought somebody said something.
I think, yeah, maybe Mike, can you mute?
Yeah, Mike.
Well, I ran 4 years ago because I think the office could have used my experience in leadership. I've worked in the criminal justice system my entire career. That's 30 plus years. I did see deficiencies in the office and the attorneys in there. And I felt that sharing my experience would improve the attorneys and the office, which would be good for all. Unfortunately, I think 4 years ago, money and politics won the day over experience and leadership. So I'm back this time to finish what I started 4 years ago.
So tell me about what your perspective is as somebody who's been on the other side in criminal cases. What sort of vantage point does that give you, or insights into what the prosecuting team should look like?
Well, I've been working on the defense side for a long time, but I don't know that it matters that much which side you're on. It's in the civil law, you work both sides of that fence all the time. The only difference between prosecuting and defending is going forward with evidence and burden of proof. We deal with that in civil court all the time. The difference would be that there's a higher burden of proof in criminal cases as opposed to civil cases, but the processes are all exactly the same. What I've got is a lot of perspective on the attorneys in the office because I have worked with all of them. And I know what their strengths are and I know what their weaknesses are. I met with them and I pretty much told them that I was, well, the younger attorneys there, because they've had an exodus of most of the experienced attorneys. So all that's left is inexperience. And I told them that I was there when they were born. I was there on their first day of kindergarten. I've watched them develop. So I'm in a perfect position to take them under wing and make trial lawyers out of them. When I was a young lawyer, I had the benefit of working with some very good trial lawyers who took me under wing and made me a trial lawyer. That's how I learned how to try cases, how I learned to be a lawyer. I've got that experience now. I am the old lawyer, so I'm in a perfect position to take those young lawyers under wing and make trial lawyers out of them. And by doing so, I think we're going to get much better results. You know, you got to get them some experience, and by getting them experience, they're going to develop better judgment. When they have judgment, they're going to end up being more efficient, and when they're more efficient, they're going to be more effective, and that's going to be the entire office. And everybody's going to benefit from that. And we're going to start getting violent crime under control.
Do you practice with others now, or have you had that experience before of kind of helping someone, mentoring someone as a trial lawyer?
I've done that my entire career. I mean, there's a lot of young lawyers that I see, you know, just when I'm at the courthouse, and, you know, I'll give them, you know, some pointers at times. I give them encouragement. There's one lawyer out there that still has a note that I gave him years ago about what a good cross-examination he did. So he shared that with me, that he kept that. That meant a lot to him, gave him a lot of confidence.
So tell us a little bit about how you would organize the county attorney's office or kind of triage the cases that come your way. Would there be would you be dividing up folks into teams? Would you be making the decision on each case and handing them out as they came in?
I envision a team approach. That's what I learned in my military days. You got to get the entire team moving in the same direction, which can be difficult at times, but it is certainly workable. What I would like to do, I'm not going to make any drastic changes right out of the chute. That's going to cause a lot of disruptions. It's got to be gradual changes. But what I want to see first and foremost is young lawyers are going to have to start evaluating their cases up front rather than sitting on them until right before trial. They need to go out and see every case that I get. I look for what I would call a donut hole. I'm just to the point where I can see the big empty hole in that case, and I know what I'm going to exploit. The attorneys in the county attorney's office are going to need to do the same thing, find those weak spots, and then go out and close them. You got to do that up front, because if you wait till the end, it's too late. You don't have time to do it, and then you've got a mess on your hands. So that's first and foremost what I want to do, is change the way they do that. Secondly, I think you've got limited experience in the office right now. You've got a couple of attorneys that have been there for a little while. I'm going to need them to assist in getting the younger ones up to speed. Overall, I want to get them all up to a higher level, but I'm going to need a little help from the more senior attorneys, and I may very well at some point put 2 attorneys on cases, more of for a learning purposes than anything. Get the younger ones some experience. I intend to spend a lot of time working with them, more than likely sitting second chair. On serious cases, I will probably take the lead, at least initially, until I can get some of them up to speed. But I want to be there and work with them, just like I learned, to give them that practical experience. So. And then it's just going to take a little bit of time to get everybody up and running.
Yeah. Okay. And so you would everybody be, do you think everybody would be trying cases?
That would be my expectation. Absolutely. That's why they're there. I mean, that office, I've spent my entire career in the private sector. I've had clients that I represented, and you have to work for the client. You have to give great deference to your clients. There's no difference in the county attorney's office. It's not just some government job. You've got clients to represent, and that's every taxpayer in the county. And, they're going to have to just change attitude. It's going to be, we're here to do a job. What I envision with these attorneys is I want them coming into the office every day thinking there's no place that they'd rather be than in that office doing what they're doing. And I want them to go home every night thinking I did good today. That's my ultimate goal. I want excellence. I want the best day in county attorney's office in the state in the end. That would be my big ambition. Now, how to get there ain't going to happen with the snap of a finger. It's not going to happen in a week or a month. It's going to take time because it's a learning process.
And talk a little bit about kind of how you would use the plea agreement. We hear from the public concern about plea agreements. We've done some stories about it certainly has its place, and it's a necessary part of the process. Do you think it's overused? How would you use the plea agreement in getting through cases?
Well, like you say, it's a necessary evil. There's not enough courtrooms. There's not enough judges to go in and try every case. There's not enough prison space. There's not enough jail space for everybody. So what it really comes down to is judgment. You have to have judgment to know which ones have to go, which ones you can work with in the community. Sometimes I look at it and it's almost random. I can walk into a room, with my experience, most of the senior lawyers can tell you just exactly who the criminals are and who the dummies are that are following along. you could end up with two different results with two people on the same incident, just based on who they are and what their backgrounds are and what we can do with them. If one guy is in there and it's his third or fourth time around, maybe it's time for him to go, where the young guy that's with him, his first time out, we can send him over to the Department of Corrections and try and get him straightened out. I would be firm, but I'd be fair. I don't want to send everybody to prison. I just want people to not commit crimes. So yes, the whole plea system is necessary, but it requires judgment, and you have to have experience to develop judgment to decide what's going to happen with that. So some of these things, the police will tend to sometimes overcharge. And I'm not criticizing them. It's just when they err, they want to err on the side of going up rather than down. Then you've got county attorneys who need to evaluate those cases, but quite often they're not getting evaluated early in the process. So rather than getting that fixed up front, getting a plea offer out there and taking care of the case, which then gets it off the table, it drags along in the system. Until you get to pre-trials right before trial. So you're creating extra work. That goes back to this efficiency. Get that stuff done early, but you have to know which ones you can do it on and which ones you cannot. So you're following this, it's a balancing act. It's necessary. You got to have judgment to get it done right. You're not going to be perfect on it every time. Sometimes you're going to do a plea because you don't have the evidence that you need. And again, that comes to experience and judgment. You've got some attorneys that would say, well, sometimes you just have to go try a case. I would differ with that. You got to have judgment. You have to evaluate your case. You have to know what you're dealing with and where you're going to end up if you go to trial, because I will not bring in a bunch of jurors, take them away from their jobs and take them away from their families to come in on a case that cannot be won. And then they walk out of there angry because wondering why they were brought in here to do that. And then the word starts spreading that, hey, we're getting drug in here to do this stuff. And it's ridiculous. Well, then future cases are in jeopardy because you've got angry jurors. I think it'd be far better off bring jurors in when you need them to resolve cases when we absolutely can't get it resolved between the attorneys. So in a nutshell, it comes down to experience and judgment and to be able to work that system. I mean, you got to be careful too, because the defense bar knows they could overwhelm the system at any time. I mean, it's just it's a nuclear weapon sitting there. If they decided to do it, they're just going to demand speedy trial on everything. And there you are. You can't possibly run all those cases through. So there's got to be a lot of work between the defense bar and the prosecutors. And again, it's all about experience and judgment and cooperation. And it's a whole system that has to work all in the same direction.
When we talked 4 years ago, and we talked a little bit about handling of domestic violence cases, and I know that you thought we mischaracterized and misunderstood what you were trying to say on that. So I want to talk through that again and be sure I understand you. So tell me what your approach would be. Would it be different than what we see now in the county attorney's office? Would there be any sort of special treatment related to domestic violence cases?
Well, domestic violence is a problem. And what I said 4 years ago was that, kind of like the OWI cases, that domestic violence became the issue du jour in the legislature. They passed reactionary legislation, which is not very good. We've got the same thing with the OWI statute. It was hurry up and get out there and do something, which they did, and then step back and say, oh, it's not very good, but hey, we're not going to fix it. So we're stuck with that. That's what I was telling you. It's not a great statute.
Yeah. So what is it about that the legislature required that is poorly written?
Well, you've got mandatory penalties on there, which takes the ability to work with these cases away. Some people would be more than willing to jump in and say, yes, I did that, I'm guilty, and take care of it, but there's mandatory jail time. That's an impediment to getting a good plea deal done. And secondly, you've got this mandatory batterer's education. I'm not saying that's a bad thing, but it is something that dissuades a lot of people from stepping up to the plate. It's expensive. It drags on for 26 weeks. And a lot of people, can't afford it, and they don't have the time to do it. So that's an impediment. You've also got federal stuff involved that if you get convicted of a domestic assault case, you can never own or possess a firearm again. That's a big stickler. People are willing to go to trial over that. So I think that they overkilled on the statute. They made certain things out there mandatory that prohibit or prevent or dissuade people from stepping up and saying, I want to take care of this. I think that as far as plea bargaining, let's go back to that a little bit, is I want people, when they do wrong, to step up and take responsibility for their action. And if they do that, then I'm willing to give them whatever break I can. I want them to not commit crimes. So I'm not out to burn people. And when you look at that domestic statute, it's out to burn them. And it causes a lot more trouble than what it solves. This batterer's education program, I had one young guy that went to that, and I ran into him later and I said, so how's that going? And he says, well, he said, there's 13 people in that class. Only 2 of us are there for the first time. And then he turns around again and says, I guess that's working, huh? Well, there it is.
Mm-hmm. So what can you do differently within the constraints of the law that you have to deal with?
Well, I have other issues with domestics. There's police are going to arrest. It's liability issues with them. So if you have some kind of a domestic situation, they're going to arrest somebody, because in the past, I'm sure some officer said, hey, just separate, go separate ways, and deal with it tomorrow. Well, in that one case, somebody came back and did harm. So now it's a liability thing. They're going to arrest somebody and they're going to keep them in jail. Sometimes I think that's probably about enough. It depends on the circumstances. There are a lot of cases that I've seen in the past where people might have a little bit to drink. They get into a little bit of an argument. One says, I'm leaving. The other one blocks the door. Then the other one decides to push through that and leave. And then the police are called. And then we're into this whole big domestic thing where we're going to have all those things I already talked about: mandatory jail time, mandatory batterer's education, all of these things. And then the both of them say, we didn't want that, got stupid, wish we never called the police. That's the type of case that, as long as there's no evidence of injury, as long as it's a first time out, and if they both say, hey, we just got stupid and we really don't want to go that way, I'm not going to pursue that. Now, if you come back a second time, you got to look at that. If there's some evidence of injury, you got to look at that. And you also have to look at it with experience, because there are cases where you've got one party that has been victimized by domestic violence, and you may have somebody back behind there saying, you go in there and you convince them to drop this, or you're really going to get it. And it takes experience to be able to sense that in a person. So that's the way I would deal with the domestics. Not every case needs to go to trial, and we don't have to, burn everybody down. It's about preventing it from happening in the future. And as long as we can get that done, isn't that enough?
Your perspective on it sounds a little bit like, coming from the defense attorney that you have been. I mean, wouldn't the prosecutor's office have to, be more of an advocate for the victims? Do you think, does it look the same from both sides?
That's what I'm getting at. In those cases, there really is not a victim. That would be the whole point here. Some cases, obviously, there is a victim. You pursue those. But in some of these cases, just the way they develop, there really is no victim. You've got a victim that comes in and says, I'm not going to testify. It starts out saying, would you please just let this go? I didn't expect this. I made a mistake by calling the police. I had a little too much to drink, whatever. Then it comes down to, I don't want to testify. And then it comes to, I'm not going to testify. And then subpoenas are sent out. Now there's threats being made that if you don't respond to this subpoena, you're going to go to jail. I mean, is that really how we want to deal with these things? I think not. So why would you want to go waste taxpayers' money, waste court time, taking a case to trial where you have a victim that says, I'm not a victim, and either I'm not going to testify, or if you make me come in, I'm going to say that's not how it happened. And then you've got a jury that you bring in, and they're not happy because they're taken away from their jobs and their families and whatnot. And in the end, they're looking at it and saying, why did you bring us in here? So it's a disaster from the beginning. No, you get those cases taken care of. You take the jury time, you take the trial time for cases that need it.
Well, I think
so. Scott, I'm curious. You talk a lot about sensing and have a sense of what the root of the problem is. How do you sense when someone is feeling pressured, one of the two parties in a domestic case, to say, no, it didn't really happen, let's just forget about it? Not pressured by an attorney, but pressured by the other person involved.
32 years of dealing with those cases. I've seen it all. You just know. You've been doing it long enough. I can tell.
I don't think we probably want to belabor this point too much more. A lot of other things to talk. But so in that case, Scott, then you would be evaluating all domestic cases that come through the attorney's office, because we've already established other attorneys are younger and inexperienced, right?
That's why we have to train them. We have to work with them. We have to give them experience. We have to develop judgment. That's where I want to be in the end.
Okay.
Obviously, I'm not going to sit down and judge every domestic case that comes through, but I'm going to work with the attorneys in the office to develop judgment on their part. That's what has to happen. And again, can that happen overnight? No. Are we going to have some screw ups along the way? Probably, because it's part of the process.
Sure.
I can't expect them to have 30 plus years of experience overnight. They need 30 years to have 30 years worth of experience.
Sure. I'm just kind of curious in relation. I mean, this came up as we're discussing the domestic issue. Is your feelings in relation to kind of mandatory sentencing requirements for domestics? Is that you have the same feelings for all crimes, or are there certain crimes where that makes sense, or should it always be more of a prosecutor's discretion in terms of punishment for crimes?
Ultimately, it's a judge's discretion, except for when you have mandatory sentencing. There was an old lawyer once that suggested, rather than spending millions on a new jail, that we buy an old convent and use that for these mandatory 2 days for OWIs and domestics and whatever, have them go in there on their honor and have one person sitting at the desk and save a boatload of money. Now, that's a political thing. As a lawyer, I'm bound by the law, same as everybody else. As a prosecutor, I'm bound by the law. There's going to be a lot of laws I don't like, but you know what? You take an oath. I mean, I took an oath when I served in the military, and that oath has not expired. I took an oath when I started practicing law. That oath has not expired. I'll take another oath that says I will uphold the law. And that's the job. Like it or not, the law is the law. Now, you have a little bit of room in there for discretion, but you still have to follow the law. I don't know. I got a little bit off of that. Does that answer your question?
Yeah, I think so. Another thing I wanted to ask about, you talked about, the county attorney's office's role in keeping communities safe. I mean, what is your assessment of the office's efforts in that regard now, and what would you do differently to actually make the communities in the county safer?
Well, my big priority is going to be violent crime. And the way you're going to stop violent crime in this community is to aggressively prosecute. And you're going to have to do it efficiently and effectively. And I want the word out there that if you commit violent crime in our communities in this county, you're going to be gone. You need to be out of here. And that's going to be a deterrent. drug trafficking is another huge problem in this county. And that's going to be another big priority. Get rid of the violence, get rid of the drug trafficking. You've got people out there that I've talked to that are afraid to walk down the street. There are people that are afraid to leave their house because of the violent crime that's going on out there. And the police are working double time trying to keep up on that. They're down officers. They're having trouble, getting people to come in and take the jobs these days because, everything is turned into, oh, let's blame the police for everything. I think that's probably the wrong approach. I support the police. Without them, what are we going to have? You've got defund the police efforts in Minneapolis. That's become the murder capital of the world. You've got a slaughterhouse in Chicago. I just read today 750 shootings in Philadelphia just this past summer. Is that what we want here? I think not. I think we got to draw the line and we got to start getting after the violent crime. And the way you're going to do that is aggressive and effective prosecution.
And is your
Scott,
sense
to kind of follow up on that?
No, I'm sorry. Is your sense, Scott, that that's not happening now?
What's that?
This aggressive and aggressive prosecution.
What I'm saying is that they need more experience. They need better judgment. They need training. They need development. They need some experienced attorney to help them, to work with them, to make them better trial attorneys. Right now, they're not getting things done necessarily. They need a lot of help. I mean, you look at trials, and some of these trials that some of them are claiming, oh, I've got a great trial record, but they're not convicting what they charged. They're getting lesser included offenses. They need to get convictions on the charges that they proffer.
And Scott, sort of on that point, just real quick. I mean, you mentioned that a lot of times the police are kind of overcharging, and so just to cover all their bases and stuff. So if you convict something on lesser charges, and that part of the process of deciding what you have evidence for or what's appropriate.
Well, the process works with the police investigating. They're going to write it up and send it over. Now, that's where an attorney needs to look at it and look at all the evidence. And again, it comes down to experience and judgment. What do we have here to support this charge? And if the evidence isn't there, they shouldn't charge it. Sometimes it's, oh, let's just go with the big charge. That way we can give it away later. I would consider that kind of lazy prosecution. You're overcharged so you can give it away. Take a plea on this so you can avoid that. Well, now they're getting people that are saying, nah, we're going to trial. And guess what? It's coming back and they're losing these trials. So you gotta know what you're dealing with. And again, it comes down to experience and it comes down to judgment. And if you sit and wait till the end, if the police out of good conscience charged higher just to be on the safe side, and you've got a prosecutor that just lets it go through, and then we get all the way to a week before trial at a pretrial, and the defendant says, I want to go to trial, and now you go look at it and say, oh my, there's no way I can prove what I've charged. Where's that getting anybody?
Couple questions.
And then you guys get a hold of it and say, oh, look, you're not getting convictions on these charges, even though it's not really accurate. So
sure. Do you have maybe some examples? And we've talked about domestics, we've talked about violent crime, we've talked about drugs. Do you have sort of in your mind a sort of a philosophy in terms of what circumstances would call for what types of charging or incarceration levels and so on?
I'm not sure I'm following the question, but
I'm trying to get to if you have what circumstances would lead to what types of charges and what types of penalties.
Well, there is no one size fits all. Every case stands and falls on its own evidence and what's there. But my thoughts are that violent crime is a huge problem and it needs to be dealt with as a priority. And I got no tolerance for violent crime. Personally, you ask me that, I think it's terrorism. People should not have to live in fear and terror because you've got people running around our communities committing violent crimes. It's unacceptable. I mean, we've got community standards here and we've got to draw the line. We're not going to accept that here. It's been accepted in other cities and look at where it's gone. We don't need that here. We've got to draw that line and draw it hard.
And then my other question, thanks, Scott. And then my other question is with regard to sort of process inside the office. There's a lot of different ways that you could structure that. And do you see everybody doing everything from beginning to end, or do you see where there would be handoffs from intake to the other processes to trial, or those would be maybe two examples, or how do you see structuring the process in the office?
Well, that would be what one of my competitors was talking about. And I quite frankly think that's ridiculous. You got to know your case. You have to get on that case early. You have to evaluate it early, and you have to stick with that case. You can't have somebody on there early and then pass it off and then give it to somebody else for trial and have one person that's going to be qualified to try the case. Everybody in that office is going to end up being a trial lawyer in my administration. That's what they have to do. That's why they're there. That's their job. So, sometimes cases get complicated. I would be happy to put two lawyers on those cases, make sure that everything gets covered. But no, I'm not going to break it down and say, oh, you do this part and then pass it off to somebody else. I mean, it's about knowing your case, and you can't do that when you're passing it around.
Is that how it's worked in the past? I mean, when I think back to when Chris Corkin was a first assistant, boy, it sure seemed like she handled a ton of cases. I would imagine there are other people in that office that we never saw in the courtroom.
That's just the nature of cases. Chris was a very good prosecutor. I dealt with her a lot, but she didn't pass cases off. She wasn't the one trying everybody else's cases. Those were her cases. Everyone I dealt with there was from front to back. She got stuck doing a lot of the felony stuff and a lot of the nasty cases, and she was very good at it. Some of the other stuff, you start dealing with misdemeanors. A lot of those are plea bargain cases because you're not dealing with injuries and victims and violence. I mean, I've got no tolerance for violent crime. I mean, I've seen people victims of violent crime. I've defended people that committed violent crimes. I'm very familiar with what goes on out there. Now, as a lawyer, a defense lawyer, I do my job. That's what I signed on for. That's my job. I took an oath to do that. Personally, I find it disgusting. So, you got two sides of every coin out there.
Do you think that kind of having that angle, that knowledge, I mean, do you think that would be beneficial for you, them leading the county attorney's office, kind of knowing that other side as intimately as you do?
Absolutely. I want every attorney in the office to be able to evaluate a case from the defense perspective. The donut hole that I talked about before, you got to have a prosecutor that's looking for that, anticipating what the defense is going to be, looking for the weak spots and figuring out how to close that hole up before a week before trial. If you wait till the end, now you're in trouble. What are you going to do? You're out of time. Get on it early, fix it. If you see weakness, get back across to the street to the investigators, say, hey, here's our problem. We got to prove this. I mean, they should be getting in there and looking at their facts, everything they've got. They should be pulling out the jury instructions. They should be pulling out the law. They should be looking at it. What exactly is it that I have to prove? And what do I have here? Can I get it done? And if you're short, you better go find what you need. That's basic lawyering.
Along some of those lines, I guess at the end of the day, if you had to put some metrics on it, and I don't know exactly what those metrics would be, I'd be open to your thoughts on that. But how would you rate the current county attorney's office metric wise, and how would you measure success?
How do I rate them?
Yeah, in terms of what metrics would you
That's
use?
the reason that I'm running, because I think they need leadership and I think they need experience. Most of the experience has left that office, and you've got young lawyers, which is a good place to start, but they need a lot of help. And I've got competitors out there that are saying, oh, they've got all this experience, but that's pretty much empty rhetoric. It's narrative built on lack of any, experience support. What I bring is over 30 years of actual experience doing this. I've got my hands dirty over 30 plus years. That's what needs to happen in the office. You need to turn these young lawyers into trial lawyers. This isn't summer camp. You got to get in there and get after it. Trying cases is not just something you get up and do. An old lawyer told me once that anybody, any painter can pick up the paint and the brush, but only a few can paint that masterpiece. Well, trial law is kind of the same way. Not everybody's cut out for it. You got to toughen up and you got to get in there and be able to slug it out.
Yeah, my question was about metrics, and I guess the question is, how do you measure success? Is there a quantitative way to measure any deficiencies in the current county attorney's office, and how you would measure success under your administration?
Well, fact is, I'm not one into measuring things and metrics. It's just basically they got to go, like I said, they got to get some experience and they got to do the job. Measurement, I don't know. You win some, sometimes you lose them. My measurement would be, I want more wins than losses. I want all wins, quite frankly. I want excellence out of that office. Now, am I going to get there in a month? No. Am I going to get there in a year? Probably not. At the end of 4 years, are we going to be there? I don't know. I'd like to think yes, but I don't know. I mean, I want cases to be won. That's the whole nature of the job. You can't go in there and go half speed. It's all in. Now, measurement, how am I going to measure it? Well, I'm going to measure it with excellence. I want the office to work. I want it to be functional, efficient, and effective. Yeah, you're going to lose a case here and there. But then again, sometimes you can plea bargain a case if you're short on facts. Sometimes you've got a defendant who just wants to go to trial no matter what. Those are the easy ones. You should be able to knock that one down with no problem. Some of them you're going to want the higher level of crime, but you might just not have enough evidence to get over the top. Sometimes it's going to be worth taking that shot depending on where you're at. And again, experience is going to tell you that. After you've got numerous jury trials under your belt, you start to realize what you can and cannot do, where the jury's going to go with it. If you just go in and say, oh, we're going to go try the case, well, that's not wise. You got to evaluate it. Experience.
And what is your experience like in terms of team leadership and managing people?
Again,
you'd have your work cut out for you to bring along so many young lawyers. So
I've got 12 years of military leadership, so I've got experience running an operation in the United States Navy with over 20 people, management. I've been in the Army. I was a leader. I've been to leadership schools. I know how to get that done. And again, it takes time. You can't just go in there and start barking orders and say, this is how it's going to go. You got to get everybody to buy in. They got to come along. You got to be out front with that. You got to lead. You got to bring people along. You got to convince them that this is the way to go. And once you get that started, then it all starts happening. And again,
what about the portion of the role of the county attorney as far as advising the county on matters? Have you experienced dealing with those kinds of issues that come up from Board of Supervisors, whether they be personnel issues,
Again, I've got over 30 years practicing law. I've dealt with just about everything. I've practiced civil law. I've done civil litigation. I've done all sorts of things in general practice. So yes, I've got experience doing that. And lawyering isn't something either that, it's not like you're locked into one certain thing. Every lawyer should be able to do all of it in time. And if you don't know how to do it right now, you put the work in, you get in the books, and you figure it out. That's what we do. So with the Board of Supervisors, a lot of that would be research time. Hey, can we do this? Can we not? Geez, I don't know. But I'll find out for you. And then you got to go do the research and advise them based on what the law is.
I think we're getting close to the time. So we've covered a lot here. I was just curious, specifically, what do you think that differentiates you from the two other men running for this position, Scott?
Well, like I've been saying all through this, experience. I've got experience. The other two really don't. They've got a lot of narratives that they throw out there, but it's not supported by any real experience. They talk numbers. One of them talks about his 78% success rate in trials. Well, most trial lawyers roll their eyes and say, what kind of lawyer keeps track of that? Well, politicians do, lawyers don't. They claim, oh, we want to take the politics out of this, but it's all politics. I've got actual real experience. I've been doing this for a long, long time. I've got leadership. I've done it. You've got one of the other ones that says, well, he's a trial lawyer and we need a trial lawyer in there. Well, what's he got for that? He went to a seminar with Jerry Spence and he told your paper back in, I don't know, January, February, somewhere in there that, well, he doesn't try cases like the rest. He might have done 10 or 12 cases. So yeah, he's got no experience in trial law. He posted up something that says, well, I sat down with DHS and juvenile court services, a learning thing, because he doesn't know anything about juvenile law. Well, that's a pretty big part of what goes on in the county attorney's office. Well, again, I've been doing that my entire career. So, I am very qualified to do this. The others, not. I also bring a lot of common sense to the table. That comes from all that experience that I have. You can't have common sense without having a lot of experience and know what you're doing. So,
any final thoughts as we wrap up here, Scott? Anything that maybe we didn't cover that you wanted to let us know?
Well, I would just throw an old Latin phrase out there that the U.S. Navy uses: non sibi sed patriae. Not for self, but for country. In this case, it's county. I am throwing myself out there because I've worked in that system for over 30 years. I see that it needs my help at this time. I am willing to go in there and do what I can to make that the best office in the state. And it's going to be good for all the communities in this county. And that's what people want. I've talked to a lot of people out there in my campaign, and people are tired of the violence going on in our communities. They want action. They don't want more politics. They don't want more talk. They don't want programs. They want action. They want to get it cleaned up. And I'm the guy that's going to get it done. The other two, they just don't have that kind of experience. People want to feel safe in our communities, and they do not feel safe. They don't want more politics. They want action.
Well, Scott, I really appreciate you taking the time to meet with us today. Thanks for putting up with the cancellation in the beginning. And
that's not a problem.
And
we finally got here, so
yep.
As long as we get it done, that's what matters, I guess. So
appreciate that. So, well, thanks for your time. Good luck the rest of the way.
Well, thank you all. If you have any other questions, feel free to call.
Thanks, Scott.
All right. Thank you.